Okay, we're live. My name is Attorney Vincent Davis, and this is a CPS Meet the Experts. And my guest tonight is Attorney Dwayne Folk. Dwayne is a Los Angeles attorney. He's been an attorney for seems like decades, and he's an expert in representing people in CPS cases. Dwayne, how long have you been an attorney?
I've been in the law 42 years, Mr. Davis. 42 years, my friend.
42 years. I knew you had been a lawyer longer than I have been.
Well, no, I started in Michigan, so I had about 5 years there. I started in 1980, took the Michigan bar exam in 82, and then came back home to California and then practiced, obviously, here since that time. And in 1988, I became a member of the California bar. And then in 1989, I was very fortunate to have a former colleague of ours, Johnny Cochran, assist me in starting my own law firm. And since that time, I have been a practicing lawyer in California.
Now, you and I met way back when doing juvenile dependency cases, CPS cases. Were you downtown or in Monterey Park?
I was both. Believe it or not, I go back to the days when we used to sit in portables and in courtrooms that were the size of closets. Wow. Then they moved us over to Monterey Park for Los Angeles County, where you and I met. That is now the court for Los Angeles County with respect to dependency matters.
Now, Dwayne is an expert in CPS matters. He's also an expert in other things, civil rights law and criminal law. Are you still practicing in those areas?
Yes, as a matter of fact, I am. I do medical malpractice defense as well, legal malpractice defense, product liability defense, and then criminal defense, as you mentioned. We do appeals in our office. We do employment. We do family law, primarily representing fathers. And then the entertainment work is television, motion picture recording, and bankruptcy. So we do a number of areas. We've done those areas for over 30 plus years. And we are primarily litigators in our office. The attorneys in my office go to court on a regular basis. They go to hearings, and they're there to represent individuals in court.
If somebody wanted to get in touch with you in the audience, how would they do that?
Oh, very simply, you can reach me via dfolkslaw. That's FOLKESLAW 57 at gmail.com. And my phone number is 747-264-7568.
Give me that telephone number one more time, Dwayne.
It's 747-264-7568.
Okay. Let me ask you this. Let's say that I contact you and I'm a father or a mother who has a CPS case. What are the top 3 most important things you want to tell me in having those types of cases?
The first thing, it's really, really important to be very careful about what you say to either the police, a social worker, or any individual in authority that's come to address a situation where they either say you have abused a child, neglected a child, or for some reason inadequately cared for a child. So my first proviso to anyone involved in this type of a circumstance is please be very careful about what you say. Think about the circumstances and do your best to try and show whatever the person in authority that is not the case. In other words, if there's say an allegation of abuse, to the extent that you can show proof or show circumstances or provide someone who can assist you, great. Now, additionally, what I would suggest is please make sure you write down everything that happens, keep telephone numbers, whether you get a notebook and put everything in it, or whether you get your phone, or however you keep your notes. Please make sure you keep copious notes about all the things that are happening so that you can follow up and contact people in authority. And then lastly, Vince, I would suggest hire competent counsel. Please get someone that knows this area of the law. Please understand that this is very, very serious. Your children's welfare is at stake, and your ability to keep them as a parent is on the line whenever CPS is involved.
Okay, here's a question, Dwayne, from Shakifa Hicks. I'm headed to trial/adjudication hearing in December. I fired my court-appointed attorney and will be proceeding in pro se. Any tips? What can you tell Ms. Hicks?
Ms. Hicks, please, first and foremost, it's in your best interest to go out and find competent counsel. If you're not in a position to afford competent counsel, at least try and consult with competent counsel. I would suggest to you also, please, don't just go online and haphazardly look up things. If you're in the state of California, for example, you can go online and look up what the steps are in a dependency court hearing and then what needs to be done. Your reading and your homework are essential. I can't stress to you, Ms. Hicks, how important it is for you to be well prepared. That means that you need to know what the witnesses are going to testify to in your case. And please think about a resolution. Have a character witness, family member, or someone who's available, who may be available to also take care of your children as an alternative as you go through the process. Do your best to try and stay focused in terms of getting information to the judge so that they can make a reasoned decision on your behalf. And please make sure whatever you do, learn and meet the requirements of whoever your bench officer is in your case. Please, you don't want to make them angry. You don't want to make them constantly admonish you about not asking the questions properly or not covering the territory of the statements that need to be done in your case. Please be as professional as possible, because you're held to the same standard as myself, and understand that you're walking into very difficult territory. And without competent counsel, you are going to be engulfed in circumstances where you're going to have to talk about evidence and what's admissible in court and how to get those documents into court and all the other things that you need. So please, even if you are not going to hire an attorney, make the best effort you can to at least consult with one.
You know, I agree with you 100% there, Dwayne. And Ms. Hicks, I'd also add this. I know you're not going to like this, but I'd reconsider the firing of your court-appointed attorney. Look, I know you may not like the court-appointed attorney, but I have to be honest with you. Even the court-appointed attorney, is going to be able to help you with things that I'm pretty sure you don't know about. As Dwayne mentioned, there's going to be tons of evidentiary law. There's going to be tons of procedural law. And then just the substantive issues themselves. I mean, I'm going to guess, Ms. Hicks, you've never done a trial. And to go do a trial regarding your children, where you could end up losing your children permanently in this case, I wouldn't try to do that lightly. Justice isn't what you think it is or what it should be. And I talk to a lot of people. On my video, my YouTube channel, I have a video on how to get a new court-appointed attorney. So if you're in California, you can have a Marsden hearing and you can ask the judge to appoint you a new attorney because there's a conflict. Now, if your court-appointed attorney is fired, you may want to consider asking the judge to appoint you a new attorney, or to appoint you an attorney to act as at least a consultant. I've seen that in juvenile courts around the state of California. And I bet Dwayne has too, where the attorney is just there to consult with the pro per litigant. So Ms. Hicks, think about that as well. Let's not let the emotions of the situation get us carried away and, do something that probably isn't in your best interests.
I would agree wholeheartedly. And I would also add that word of mouth is the best possible way for you to find someone. So if you are in a position to at least maybe visit the court before you actually go on your court date, you will see other attorneys and maybe you can talk to someone and hopefully get some advice.
Very good. All right, let's take a question, Dwayne, from Margaret LeClaire Buff. Is there anything that can be done when the biological father's girlfriend writes lies on a 388 petition to the court?
Of course, there are many things that you can do, but the first thing I would suggest you do, rather than calling them lies, prevarications, or however you want to address it, call them issues that you need to address as the mother in this case. And with respect to those issues on the 388 petition, try and look to things that you know you can refute or rebut, and then provide the proper and appropriate evidence so that it can be addressed. Otherwise, all you're going to do is just spin your wheels.
All righty. I agree with you 100% on that. Here we have another question from Virginia. I have a DCS severance trial in January for 2 days. Will those 2 days be the last?
That is terrible to hear that you're in the last part of what we call a review hearing, where the court is making a determination of whether or not they're going to do adoption with your children, or whether they're going to have a plan that we call a permanent plan that doesn't include you. It's critical in the state of California that when you go to that hearing, you be well prepared. We want to do everything we can to show the court that you're the best parent or the best person, along with the other parent or whoever else is involved with your children, to raise your children. It's critical at that hearing that you show the court all the reasons why it's a huge mistake to do what they're doing. Now, if you do have that happen, you're going to have to appeal that immediately. That is critical on your part. And then, interestingly enough, in California, you do have the ability to have the court reconsider this even years later, but it's very difficult. So what I would ask of you is, please prepare for that hearing and get experts, get individuals who can speak of your good character, your ability to parent in an appropriate fashion, teachers, physicians, pediatricians, any persons, family members, ministers, rabbis, any individuals who can help you in terms of putting together a comprehensive package of yourself so that you can present that to the court, so that in no way, shape, or form they can say no to you as parent of your children.
All right, here's another question from Raquel Ramirez. Quick question. I'm in California and my sister is dealing with DCFS, and she's expecting to be reunified with her kids. Court date set for the 10th of this month. She has done all court-ordered services and classes. Okay, so I'm not sure what Raquel is asking. Maybe she's asking, will she get her kids back?
She's probably concerned about getting her children back, or her sister getting her children back. And that's one of the things I will say to you. I gave up the turban and the crystal ball years ago. I don't make predictions, but what I tell people is that go the extra mile. For example, let's say you've done all of the things that the DCFS has required. You've done all the classes. Well, take some webinars, read some books, subscribe to Parenting Magazine, do all kinds of things above and beyond what's being requested of you, so that you can add those things to the court, so that the social worker involved in your case can say, this parent is very conscientious. They went beyond what we had requested of them. And it's not too late for your sister to do this. She can get on and get into a webinar, or look for certain books or things that she can come to court and establish and show the court, Your Honor, I need a last minute. In other words, we put that before the court in Los Angeles County. We call it a last minute update, and ask your social worker to do a last minute update to show the books that you've read, the webinars that went in additionally with that. That will look great when she comes into court for that last hearing, what we hope is the last hearing.
All right. Here's a question from Barbara Bernard on YouTube. It's been over a year now since the older boys who are still with me have had a visit with their sister without any attempt by CPS to help us with reunification. How can CPS keep siblings apart?
They're not supposed to keep siblings apart. There usually has to be a rationale. For example, sometimes you unfortunately get situations where children may get into relationships with each other that are inappropriate or certain things like that. But other than that, it's imperative on your part to show the court how this is damaging your children. In other words, maybe you have a minister or a rabbi or a priest or someone who can come forward and say, yes, we used to bring the family together for Sunday school all the time. Now they're not allowed to do that. It's damaging the younger child in this particular way, or damaging the older child in this particular way. That includes also through your pediatrician. Maybe this is the time for you to consider actually having some kind of counseling with your children, so that you can physically establish that this is harming them, that their time apart is not helpful. Hopefully that gives you some insight.
Very good. Jamie May says, my judge and lawyer and everyone else had me believing I couldn't get another lawyer. And I think that comment relates back to us telling an earlier questioner, maybe you can ask your judge for another court-appointed attorney. I'm going to assume Jamie May is in California. Both Dwayne and I are licensed in California. Although, Dwayne, are you licensed somewhere else? You're licensed in
I'm
Michigan.
also licensed in Michigan, but I don't practice in Michigan. And I have reciprocity with New York, Florida, and Texas. And I do spend time in Nevada from time to time. But most of the time, 90% of the time is spent in California.
All right. Well, Jamie May, if you're in California, you can make a Marsden motion and you can request a new attorney. Now, that doesn't mean that the judge is going to grant your motion and grant you a new attorney. But, you can always go out and hire a private attorney if you have that ability. Otherwise, you're going to have to work within that court-appointed system.
Right. Also, what else I would mention, Vince, is understand that a Marsden, M-A-R-S-T-E-N hearing comes from the name of the case, and the idea came from a public defender in a criminal setting. And the idea being that particular lawyer was not handling that person's case in a professional manner, or there were issues of conflict between the lawyer and the client, to the point where the court will review everything. So please, if you go about the opportunity to do a Marsden hearing, as Mr. Davis Vince is suggesting, and I think it's a great idea, please make sure that you're diplomatic about it. Don't go in there and just, this lawyer doesn't call me back, and they don't know what they're doing. And don't come with just things that are going to be difficult for the court to understand. Be specific. I waited on this date. I never got a return call. I sent this letter and asked for help with X, Y, and Z. Didn't get any opportunity to get that work done. I need X, Y, and Z subpoenaed. The attorney hasn't done the work. Do things that are substantive that the court can go, wait a minute. Yes, you're right. I think maybe you do need a new attorney. I'm going to get someone that handles this type of circumstance for you.
You bring up an important point that I sometimes skip over. But I know you and I have talked about this in the past. But presentation to the court is extremely important. Wouldn't you say?
I would say that that's 70% of your case. Now, obviously, it has to be substantive in your presentation. What do I mean by substantive? You need to have the facts together. You need to have the applicable law. But it is critical because in the family court arena, especially in children's court, especially in Los Angeles County, and not only Los Angeles County, throughout the state, many times you're going to get a disjointed hearing. In other words, there are going to be interruptions in your particular hearing to the point where it's going to drive you crazy, especially if you're not a seasoned, experienced attorney. So what I would suggest to you is when you make a presentation, have everything written out. You don't have to follow it exactly. It's not a script. You need to be listening to what's going on, but at least have a list of things that need to be provided, check them off in an organized manner, and give the court in a very concise, very short. You don't get 30 minutes to talk. You just answer the question and go on. That is critical, because without that, we as your lawyer, we're not going to be able to help, no matter what.
All right. Here's a question or comment from Colette Lopes. My private attorney has stopped communicating with me. Please help me. Trial in 23 short days. My worst nightmare is coming true. What would you tell Ms. Lopes at this point, Dwayne?
Ms. Lopes, I would ask you to please, in a very calm, very professional manner, reach out to your attorney and indicate to your attorney your trial is coming up in 30 days, within the next 30 days. You're very concerned about the circumstances, and put in writing those things that you want your attorney to address. You're going to need witnesses. You're going to need documents. You're going to need information. So have that all available for your attorney. I would suggest you do it by email. I would suggest that you do it by snail mail with a certified letter and a return receipt, and that also you call. Now, lawyers, I don't use the B word, as we jokingly call it in my office, the busy word, because I find, Vince, that people aren't busy when I have a check for them. They somehow have the time to get there right away. So what I'm going to suggest to you is don't buy into circumstances where your lawyer is saying, oh, I'm too busy to talk, or I'm busy right now. Just be conscientious. Now, don't be obnoxious. Try and do your best to, start off with the email, with the telephone call, with the mail. If that doesn't work, try within the next 3 days after that to reach out again by email and telephone. And then I guess if you cannot get them by the close of the week because your time is of the essence, I would suggest that you ask of that secretary in that lawyer's office, or whoever administrates that lawyer's office, can I please come and see you? What date next week? And make sure when you come, please have all the requisite information, have your file, have your documents, have the phone numbers and addresses and things that are necessary for your lawyer to be helpful. And understand that your lawyer probably is not on purpose not contacting you. They may be in trial. They may have a family emergency. Lawyers are good about contacting people and following up for trial. That's part of what we do as our process. So if you're not able to reach out to your lawyer and he or she's not responding, just be persistent.
All right. Here we have something from Miss Blackwell, Tatiana Blackwell from Alabama. I live in Alabama and my children have been out of my home for over 60 days. I have done everything from visitations and classes they have asked me. It says DHR has lied and delayed my process in every way they can. I have seen a significant decline in my children since they have been gone. I do not have a court date. Is there anything that I can do? Now, Ms. Blackwell, as you may have heard, I'm licensed in California. Dwayne is licensed in Michigan and California. And but we're going to answer this question as if you were in California. Dwayne, what would you tell Ms. Blackwell if she was living here in California?
Thank you for that disclaimer, because I don't want to be accused of the unauthorized practice of law in Alabama. But what I would suggest to Ms. Blackwell is talk with your attorney. I don't know if you have counsel, you need to speak with your attorney. And as I told the last caller or a few callers prior, do some extra things, do some webinars, read some books, seminars, add to whatever it is that you're doing, not just to stay busy, but also to show the court that you're going above and beyond. And then you're going to need to find out what the procedure is in your state for what we call walking on a matter, or what we call in our area ex parte proceedings. In other words, we give notice and then the court will allow us to get a date and time to go in on that particular matter. So what I would suggest to you is that if 60 days have gone by and you feel that it's detrimental to your children, this is your opportunity to get with your pediatrician and establish the things that have happened that have harmed your children in a way that you know you can do better. Follow up with their educational needs, with their physical needs. Do everything you can to request as much visitation time as possible and work with that department or that social worker or group of social workers to get more time with your children. Just, you're going to have to be consistently, not obnoxious, but just consistently making inquiries about your children. Not every day, but at least once or twice a week at a minimum.
All right. Here's a question from Denise, and I guess it's Quee. They put a restraining order on me on false pretenses. I love my kids. Please help. It's because of COVID they took any communication. What do I do? What would you tell Denise? Assuming she lived here in California.
First and foremost, whatever the circumstances were regarding your restraining order, you're going to have to determine that this is not going to be permanent. I don't know what the status is of the restraining order. I'm going to presume that this was an initial restraining order that was done by the court. So the best thing that you can do is follow up on whatever it says that you did wrong in that restraining order, to cease and desist from it, and then try to follow up with those family members or other individuals who you know can give you a good character reference, physicians, psychologists, counselors who can also give you a good reference in terms of your circumstances, and show that it's imperative you have the opportunity to speak with your children.
I would agree with you wholeheartedly, Dwayne. All right, we have a question here from Carissa Don Umbrino. I have a question. Why is it videos aren't permissible in California state court, yet if a murder was happening, that would be permissible if it was recorded? Meanwhile, CPS workers, you can have things about them on a video, or foster care mothers, but you can't put them into court for evidence. But yet, if there was a murder going on the street, they can be reintroduced in court. I'm confused. Hold on a second. I'm confused on the laws. Okay. So, Carissa, one of the things is in California, there's a law that you can't record someone without their knowledge. All right. And if you do, the rule is very, very strict. It's not admissible anywhere, not in an administrative hearing, not at a subsequent judicial proceeding, nowhere. It cannot be introduced. However, like everything else in California, there's many exceptions to that rule. One of the exceptions is the commission of a felony. Murder would be a felony, and you can record a person without their knowledge if they're committing murder, and it will be introduced in court against them. So that is the reason why there's, a discrepancy. Many times in the law, there is a general rule, what we call from law school, Dwayne, it was just general rule.
Yes.
But there's all kinds of exceptions to general rules.
That's correct.
Right? I remember, the hearsay rule is out of court statements couldn't be used in court to prove the truth of the matter stated therein. Now, that's the hearsay rule. But there's 100 exceptions. There's statutory exceptions in the evidence code, and there are many, many cases that allow hearsay. One of the hearsay exceptions is in the CPS venue. a social worker can use hearsay, multiple hearsay, to prove a case of abuse. And there's a lot of rationale that was given by our court, our Supreme Court, for allowing that to happen. I don't agree with all of those, but that I don't make the law. I'm not on the Supreme Court. So, Carissa, there's many exceptions. There is a general rule, and there are many exceptions. Sometimes, though, here's what happens a lot of times when I talk to people, Dwayne. People will call me up and they will ask me, well, isn't the rule blah, blah, blah? And what they're citing is one of the exceptions. And, they kind of got the analysis, the legal analysis, it's kind of out of whack. It would make sense if they knew the general rule, knew the exceptions and the rationale for those exceptions, whether you agree with them or not. And then you have a better understanding. But if sometimes people come to me and they cite one of the exceptions and they can't figure out, well, why is the general rule, and they don't realize it's the general rule, exact opposite. And it doesn't make sense. And I tell people all the time, it's hard. It's hard to do a trial because it takes, first of all, an intimate knowledge of the story, the facts, but also of the law. And one of the laws you have to know is the evidence code. I tell people all the time, I think the evidence code is probably more important in a trial than the Welfare and Institutions Code.
I would agree 100% with you. And I would also add that what people need to understand, and especially your caller with respect to various evidentiary rules, the idea is reliability. So what the court wants is to make sure that whatever is coming before it has a strong factual basis. And that's why we have so many rules concerning out-of-court statements. There's about 32 exceptions to the hearsay rule. And then, as you said, Vince, obviously a lot of court cases and over 100 different interpretations of various rules. But one of the things I stress to my clients with respect to evidence is that it is critical that I know everything that they have. In other words, don't surprise me with anything. At the beginning of the case, let's sit down and go through all the documents you have. Let's talk about where you've gone to the doctor, where your children have gone to the doctor. Let's follow up on school. Let's follow up on counseling, or all the things that are going to be helpful to you. And then let's look at the circumstances of getting that evidence admissible. Sometimes it's going to be allowed and sometimes not, especially I found, Vince, in the dependency area of my practice. The judges, unfortunately, they're just not as critical about allowing evidence in. So, it's almost to the point of what we call administrative hearings. In other words, the judges in juvenile dependency court almost err on the side of allowing as much evidence and testimony as possible because the bench officers want to make a competent decision. So I believe in children's court, in dependency court, you're going to find that the judges are going to have some relaxed standards in terms of evidence. Now, does that mean that you're going to be able to ignore the rules of evidence? Of course not. Does that mean that you're going to be able to get everything in you believe is relevant and should be in your case? No, of course not. But I would strongly urge you to get with your lawyer and address any and all of the potential evidentiary issues before you go to court. So that way we won't be like the young lady who just asked the question and time is running out.
For you that just joined just joined one of the shows on one of the social media platforms, I'm Vince Davis, and tonight my guest is attorney Dwayne Folk. Dwayne is a 45-year attorney from Michigan and California. He's
about 42.
42. Okay. I gave you a few extra years. 42 years. Dwayne is an expert in CPS cases. I met him maybe 25 years ago,
At least.
maybe longer, in the juvenile dependency court. And he is an excellent trial attorney.
Oh, you're very kind. You're very kind.
All right, so we have Raquel Ramirez. Can the sleeping arrangements be a reason for her not getting her kids back? We got twin over full bunk beds and plan to have daughter on top, who's 7 years old. Two boys ages 4 and 7 sharing the bottom, a full bed. Caseworker said that wasn't okay, that the boys can't sleep together. Now, I'm going to assume Ms. Ramirez is in California. What do you say about that one, Dwayne?
Ms. Ramirez, please do your best to figure out a way to better take care of your children, not to criticize you, but to take care of your children, at least in terms of getting them separate bedding. Even if you get another bed that's next to the bunk beds, for example, or set up within that particular room a specific set area for the boys and for your daughter. I think that you're facing some difficulty on two fronts. The first one being that you're having the boys and girls sleep together. That sometimes is difficult, especially when they get to be a little older, but if they're children of a tender age, say 3 to 5 to 7, then my suggestion would be find another bedding circumstance for the other son so that all three have a separate bedding. If you can set it up where they have their own rooms, that would be great. Obviously, you may not be able to do that, but if to the extent that you can separate the children and give them more space and make the living arrangements comfortable for everyone, I would strongly urge you, please don't let those kind of circumstances keep you from your children. That's cosmetic. That's something that you should be able to figure out. And without knowing the ramifications of how your house or apartment or townhouse is set up, I can't give you specific advice, but do the best you can to have separate bedding, separate rooms, privacy, however you can for each child. That's important.
Okay, here, Dwayne. Here's an interesting question. Margaret LeClaire Buff writes, is it legal to use a tracking device on a child who goes for a visit with a non-custodial parent? And I'm going to assume Miss Buff is in California, and I'm going to assume this is a CPS case. What do you have to say about that?
Wow, that's an interesting phenomenon, Miss Buff. I would have to do some legal research, but I want to err on the side of being conservative and telling you, be very careful about having a tracking device on your children. I know that you may be concerned about their whereabouts and their circumstances, but I don't know if that would be found to be appropriate with respect to how you're taking care of your children. It may even be frowned upon by the social worker because they may feel that you're impinging on the non-custodial parent's time. I don't know if that would be appropriate. I would urge you not to do that until you talk with your own counsel and maybe provided specifics of why. For example, if your case involves some inappropriate touching or something, well, now I understand. Maybe that might be a rationale for you to be allowed to make sure your children are where they're supposed to be, but that's with the permission of the court. I don't think you should try to do this by yourself. I wouldn't. I would be very careful.
All right, here's Denise asking us a question. Hold on, let me scroll down to make sure I can read this correctly. Denise writes, please respond to Art Gamboa. COVID started in March 2020 and didn't have a trial until 10 to 11 months. I was in a inpatient rehab. I attended all visits, and after they terminated my rights and didn't want to give them to family members, and they put a responder due to a post on Facebook saying that how CPS was wrong in taking children away. Please help since the begging the social workers have pushed for my boys to be adopted out. I had a good relationship with the foster mom, but the worker intervened by social worker. So I'm not really clear on that question, Denise. What do you make out of that, Dwayne?
Well, I get the feeling that she is facing some very serious circumstances of losing custody of her children permanently. So I would suggest to her that if they have terminated her parental rights, she needs to immediately file an appeal if she has not done so. But if the time has lapsed, she needs to find competent counsel and get with that attorney and make a plan in terms of trying to get the court to revise its ruling. I mean, you can't rest on your laurels if your parental rights have been terminated. I mean, that's so serious, and time is of the essence. You've got to address those things immediately. I wouldn't depend upon the social workers in your particular circumstances. I would immediately try to get my attorney involved in getting either 388 filed or something filed on your behalf, an appeal, something to be able to get the court to know that you are the competent person to parent your children.
All right, here's a question from Connie Tollfree. Why are appeals so hard to win? Grandmothers should get their grandkids. How can they, CPS, say the grandmother must have known of the abuse? This is one of those cases. I was talking to someone about this today. A grandfather came to see me, and they didn't give him the child after the child was detained because they said that he must have or should have known that his daughter, who didn't live with him, was using drugs and therefore a risk to the child. So I think that's where Connie is going with this. What do you think about that, Dwayne?
Wow. I've spent a lot of time over the years, Vince, representing grandparents, and have cases that establish grandparental rights that we have appealed. What you need to understand, and I do appeals as a part of my practice, that 97% of the appeals that are put together are not successful because you're trying to either change the law, uphold the law, or find a new way of applying the law. I love my appellate practice because it gives me an opportunity to make things better. In other words, I get to decide what it is that the legislature should have done with whatever the issue was and then address that. Vince, you may remember we were very fortunate recently within the year to have won a case on appeal with the Ninth Circuit Court of Appeals. That's a very serious set of circumstances, federal court, and it's very difficult to win those cases, but we were able to establish new rights for parents with respect to issues of social workers and doing irresponsible things. So what I would suggest for people when they're trying to appeal, find a theme, find a rationale as to why you should have won, why the grandparents should have been considered. The law requires it. And especially if you're not living with that particular child or the parent, you should be able to establish that you're the proper person for the welfare of the children. That don't let them force the issue on you saying, well, you should have known. I would suggest that you fight that and that you go to court and present well-briefed arguments to establish why that was a mistake. There's plenty of case law out there that says placement should be with someone that is a family relative, not someone who is not a relative. So that's what they're supposed to do initially. So let's say, for example, in the case you said the grandfather should have known, well, is there an aunt? Is there an uncle? There's got to be someone out there who they can't make that argument about. And I would suggest you have that person also in your arsenal of people to help you get your children.
All right, here is a comment, and I'm going to mention this comment because I spoke to someone today at my office who is from another county in California, and they allege the same thing this viewer is alleging, Miss Courtney Lynn Kinney. Pacific Toxicology is being investigated or investigation for altering test results. The run the test results of Altadena Recovery and other DCFS court-ordered testing sites. So, Dwayne, I think what she's saying is there's becoming, a movement growing within alleging that these testing sites are making mistakes or outright just altering mistakes, altering drug tests. I've heard these things going back, 25 years, 30 years, however long I've been doing this. But I hear and see it more and more and more. What do you think about that?
Well, I do remember years ago there was a matter with U.S. HealthWorks, and they were having some issues that the court eventually followed up on, and both U.S. HealthWorks and the court were able to make a number of changes to make things a lot easier and better for people who are going for testing and following up. I've heard those rumors from time to time. I mean, I've even heard people say that they, were offered to pay for test results and those kinds of things in terms of bribing the individuals. And, Vince, what I would just suggest is that you got to take a lot of this stuff with a grain of salt. If there's an issue with your testing and you think that there's a problem with it, I would strongly urge you, spend the $15, spend the $30 and go get the drug testing done yourself. Go someplace that DCFS utilizes. That's not the place where you were ordered to be tested. That's not to say you disobey the court order. Obviously, you do the testing from wherever they have you go. But remember, your children are on the line here. You're trying to regain your parental rights and have your loved ones come home. So if that means you spend a few extra dollars doing your own set of drug testing or alcohol testing, do it. So that way you can get that issue out of the way and have your lawyer provide those tests with the idea that, you're going to do 6 tests or a number of tests, and then you're going to be done. You can't have this going on forever. At some point, you need to show the court that you're not on alcohol, or you're not on drugs, and that you're responding and following the court's orders in a great fashion, so that the court will give you your children back. Period.
Right. Carissa Umbrino writes, exactly, pay for a hair sample. Carissa, tonight, I met with someone right before the show at my office, and I advised her to go out and get a hair follicle test. Because over the past 3 or 4 months, there have been issues, and they're weird issues, that the social worker has brought up about the client's testing results. And, Dwayne, one of the things that we overlook sometimes or forget about sometimes is, in order to get scientific evidence into evidence, there has to be a very strong foundation checklist of things. And in juvenile dependency cases, I find that we just accept whatever the testing facility says. Test clean, test dirty. That's it. But we never look at the rest of the things to find out if this is really an admissible test. What do you think about that?
I have had that circumstances where I have actually fought this, but they were circumstances where, for example, my client maybe they had some kind of health circumstance. And so they test positive for some kind of substance, but that substance is related to the medication they're taking. So I've had those kind of circumstances where we've questioned the results because we've said, wait a minute, this person is on dialysis, or this person is taking cancer therapy, or whatever it is that is causing a false positive. Those things I've seen. Now, with respect to just accepting the results, it depends. I mean, I don't know if this has come up recently, but I know in the past I've had circumstances where we've questioned the results from various drug tests. But like I said, that was because my client in those particular circumstances had medical data to show, hey, this is not appropriate, or hey, I didn't test positive for this because if I put that in my system, I would die. I mean, believe it or not, there are circumstances where they show certain drugs in people's system that isn't there. I've had that happen, and I've had to show, well, the reason it came up as a false positive is because they were taking XYZ medication.
Have you heard anything about federal regulations? How does it go? If you take a drug test and it tests positive and you ask for a retest, if they don't do the retest, that the original test can't come into evidence.
That's true. I've seen that happen before. I've had that happen very rarely, but I remember, once again, U.S. HealthWorks had a circumstance where a client was a bus driver, and this was an issue where they were saying that they were taking medication, and there was a false positive that was provided. They asked to be retested. They weren't retested, but Vince, that was a circumstance where I could show the court my client was taking medication, and that was the reason for the false positive. You got to have some rationale. I don't think you can attack these tests without either having legal basis or scientific basis based on, an expert that comes in and says, Mr. Folk, they didn't do X, Y, and Z properly, and that's why you had this result.
Every county that contracts with a drug testing facility, there's a contract. And I remember in a couple of cases, I've done actual discovery where I've gotten a hold of that contract. And each of those contracts talks about, the parent requesting a retest and how important that is, because that contract is trying to comply with federal regulations so they can get the federal money.
Exactly.
Right. But it's a very interesting subject. I might do a show on that, because drug testing is the focal point of so many of these cases.
Exactly. Not only drug testing, but also alcohol. Alcohol also comes up a lot as well. I think alcohol comes up more than drugs. Now, the other question you have, and there have been recent case law on this, so it's In Re Mauve, and that was a case I was speaking to you about recently that just came out this year. And in that case, the mother was actually using marijuana, and they were able to allow her to do that because it's a legal drug, So the idea is that, if you can avoid using drugs, obviously you don't do it. But if it's a drug that's legal, you're going to have to walk a very narrow line and make sure you prepare a defense that shows, you using a recreational marijuana, edible or whatever it is you're doing is not affecting your ability to be a competent parent.
Right. Okay, here's a question from Jamie May. My lawyer told me my unborn would be taken from me right away when he was born if we lost our case, and that they only had to prove one accusation to be true, and due to my not understanding what was happening due to my disability. And my lawyer also saying I would be signing my parental rights over, I would be able to add them. Add them still, and that I would get medication, be able to keep my unborn son, and my kids would be within the person they were with at the time. Everything I was told was
It's probably going to be a lie.
yeah,
You're
a
probably saying
lie.
a lie.
Have you ever come across that where people, have taken somebody's advice, sometimes a social worker, sometimes an attorney, sometimes a friend, and they have been given wrong information?
Vince, my very first case in dependency court was a child, 3 days old, addicted to crack. So I know this area of this practice very, very well. And I have had parents who have had physical disabilities and been in children's court and had to fight to keep their children and been successful. And what I would suggest is you have to get a competent team together. This is not something you're going to be able to do in pro per or hit and miss getting an attorney, because a lot of times you can get great attorneys on the panel for the courts that are appointed because they do this every day and they're familiar with the circumstances. But ma'am, in this particular case, I would strongly suggest to you that you ask the court to get you some kind of specially appointed a lawyer that addresses issues of your disability, get your physicians involved so that they can see and understand that you can be a competent parent with whatever this disability is that you have. And yes, that person is correct when they tell you that if you've had a child removed, the possibility of having another child removed that you're carrying in the womb is a substantial possibility. It's not unusual that happens. So my suggestion to you is to strongly get together the most competent team available that you have and address the circumstances. Get your children placed somewhere that is someplace that you feel comfortable and the person that's dealing with your disability feels comfortable, so that you work as a team. You really need help. You cannot do this by yourself.
All right. Here is our last question of the evening. It's going to be from Shakita Hicks. And it says, do both of you guys agree that social workers have way too much power and allowed to lie way too much without being prosecuted criminally?
Wow. Well, you're talking to two lawyers who spend a lot of time in court, and Mr. Davis's office sues the Department of Children and Family Services throughout the state, throughout the country on a regular basis. So, Ms. Hicks, understand they don't all get away with it. There are times that we are able to address it. Now, do they have too much power? I don't know. I've had circumstances in the days when Vince and I came along, we represented children, and I had children that were physically abused. I've had children that have had sexual abuse. I've had all kinds of circumstances, and I feel like the social workers didn't do enough. So it just depends circumstance by circumstance. Sometimes you're going to get competent social workers, and sometimes you're not. It's just like lawyers or doctors or any other kinds of professions. So what we would suggest for you to do is try and cooperate, get competent counsel, even though I guess you're representing yourself. So you need to follow and adhere to all the court's orders. And once again, I would strongly urge you, rather than concentrating on whether people have too much power or not enough power, to figure out how you can work within the system to get your children back, period.
All right. Hey, Dwayne, we've come to the end of the hour.
That was wonderful. I really enjoyed that. Thank you. I didn't know how this was going to be, but you're great at this. Thank you.
So I would ask, first of all, I want to thank you for being a guest tonight.
Thank you for having me.
Secondly, I want you to think about whether you'd be a permanent host for one of these shows. They're on morning, afternoon, and evening at 7 p.m. And we're trying to get enough hosts to do it 7 days a week. So if you wanted to devote 1 hour per week.
I'd be happy to, Vince.
Because with your experience, I mean, your experience, I personally know of your experience and your expertise, and you would be well qualified to jump on one of these shows and handle these questions and, interview guests yourself. I know you used to be on TV and radio, and so you have that kind of experience as well. But I want to thank you. The last thing I want you to do is I want you to give the audience your telephone number and your email address one more time. So if they want to contact you, they will be able to. Go ahead.
Thank you very much. My telephone number is 747-264-7568. And my email address is DFOLKESLAW57. That's folks, dfolkslaw57@gmail.com.
All right. Thank you again, Dwayne. Everyone watching, I want to remind you that tomorrow night, we're going to have Aaron Carranza, the CPS Family Reunification coach for reunification services and motivating, helping people do their FR services so that they can get their children back quicker and faster. And that's going to be, Aaron will be on tomorrow night at 7 p.m. Pacific time on these same social media channels. All right. Thanks again, Dwayne. Good night, everyone.
Good night.